On October 7th of last year, Hamas terrorists invaded Israel and staged a barbarous pogrom, an attack unlike anything we've seen since Nazi paramilitary death squads, Einsatzgruppen, struck Israeli communities in Eastern Europe during World War II. On October 8th, Hezbollah began to rain missiles from southern Lebanon on Israel's northern regions, making tens of thousands of Israelis internal refugees. These and other attacks by other terrorist groups were orchestrated as part of a long war being waged by Iran's Islamist rulers. Their openly stated war aim is not a two-state solution or a peace deal or a negotiated settlement. It's simply death to Israel. Their words, not mine. Officials at the UN, other transnational organizations, various non-governmental organizations, and media platforms, what is called, more hopefully than accurately, the international community, responded, mostly by aiding and abetting the murderers, the rapists, attacking Israel with a campaign we've come to call lawfare. Natasha Hausdorff is a young British attorney, legal director of UK Lawyers for Israel, and an extraordinarily articulate voice fighting those who are using international law, or rather distortions and inversions of international law, as weapons in the genocidal war being waged against Israel by the Islamic Republic of Iran, its allies, its proxies, and of course, its fellow travelers and useful idiots. I'm immensely pleased she's with us here at FDD today. Also with us is my colleague, Orde Kittrie, a senior fellow here at FDD, an international lawyer, and law professor at Arizona State University's Sandra Day O'Connor College of Law. Orde spent more than a decade at the U.S. State Department, and he's the author of Lawfare, Law as a Weapon of War, from Oxford University Press. And thanks to you, too, for paying us a visit here on Foreign Policy. Well, first of all, welcome to Washington. Welcome to FDD's headquarters in the studio. I've followed you for years, so it's wonderful to meet you in person.
Well, thank you so much. I'm extremely grateful for the very kind introduction, especially being called young, which I will take. I think we all feel a great deal older after the last 12 months. But
that's true. It's been a stressful 12 months, but you haven't gotten any gray hair. Or your hair was already gray, but I don't think, but maybe grayer still.
Indeed.
Okay, I'm going to begin, Natasha. I'm an old reporter. I'm nosy. Curious is a nicer word. I think a lot of our audience is. Tell us some of your story. Tell us where you come from a little bit and, which roads you took to get here and why.
Well, I started my legal career after my law degree at Oxford, actually at an American law firm. I was at Skadden Arps in London and in Brussels. And I was there during Sukeitan in 2014, which is, I think, one of the instances in which I first saw international law being used against Israel on such a broad scale. I'd been aware of the phenomenon of lawfare prior to that. Certainly when I focused on the law of armed conflict in my university studies, the manner in which the law was misrepresented against Israel was very much at the forefront of my mind. But after my time at Skadden, I spent a year in Israel. I did my master's, which was focusing specifically on the law of armed conflict, international humanitarian law, and I spent some time clerking at the Supreme Court in Jerusalem before I came to the bar in London. Now, we have the split profession between barristers and solicitors. So as barristers, we wear the wig and the gown. And I've spent some 8 years now doing trials in court most days until, I would say, October, where this aspect of the international legal fight against Israel really started to take over a great deal more of my time. I've been extremely privileged to work with UK Lawyers for Israel for some 10 years. So a voluntary association of lawyers working for the proper application of law to Israel and Israelis, combating anti-Semitism. But our work and our efforts in the last 12 months have been unlike anything that's come before.
Yeah, I'm sure it's been intense. Let's not assume too much. What is international law? And I particularly because there's no parliament to write or pass legislation. There's no executive to sign legislation. There's no justice system to enforce legislation. There are courts, but I would argue, we'll get to this in a little bit, that they violate international law for political purposes on a pretty routine schedule. And by the way, Israel, I think it goes without saying, or at least it's been demonstrated, is never presumed innocent.
I think that's a fair assessment. So international law began as a very different phenomenon, regulating interaction between states in minor circumstances, the law of the sea, international trade. Much of what we refer to as international law when we're talking about Israel tends to be the law of armed conflict. Now, that is a body of law that has evolved substantially since the Second World War. And the main treaties, if you will, international conventions that seek to codify an awful lot of that part of international law are the Hague Regulations and the Geneva Conventions. So to a certain extent, law is written down and it is agreed between states. Treaty law is something that states sign themselves up to and bind themselves to, a little bit like a contract, if you will. But there is another aspect of international law which is very unlike any kind of domestic legal system, and that's what's called custom. Now, customary international law develops over time. It's not necessarily written down anywhere, although it may be analysed in textbooks, and I'm sure it forms a significant part of what Orde teaches. But custom develops over time out of state practice. So if states are behaving in a particular way, believing themselves to be legally obliged to behave in that way, after a certain point, they become legally obliged as a development of a rule of customary international law. And the development of international law more generally, the detail that is being introduced with more treaties and more decisions of international courts, it has turbocharged, certainly, in terms of the complexities associated with it. And as you have rightly pointed out, the politicization of certain aspects of international law.
A couple of questions occur that we try to go through, but important. So the most solid basis of international law, you would say, would be treaties, because that's a nation voluntarily undertaking an obligation.
And they can be bilateral between states, yes, or multilateral international conventions.
So just to take one example, might be the treaty that the UK signed with the People's Republic of China, that the colony of Hong Kong would be given over to the government in Beijing, in exchange for which the government in Beijing agreed that for 50 years it would be one country but two systems. That treaty has been violated egregiously and obviously. So what? Beijing doesn't care. No one's going to enforce it. No one's going to do it. No one's going to do anything about it. No one has. The Islamic Republic of Iran has violated international treaties it signed. Nobody really cares. There's certainly no consequences for that. And then I'll ask this to you, and you can both respond to it. When we talk about international humanitarian law, the law of armed conflict, the basis for that is that civilized people said, look, there are going to be conflicts, but let's make them less brutal if we possibly can. So let's agree that on both sides, we won't use poison gas. It's a terrible way to die. We're going to shoot at each other, but we're going to say there are certain limits to armed conflict. Israel, for example, totally buys into this. Hamas doesn't recognize that at all. There are no limits to what it does, neither for Hezbollah. Absolutely, they don't recognize that this exists in any way. And
worse than that, they use Israel's compliance with international law to their own advantage.
To their own advantage. So they, for example, Hamas openly uses Gazan civilians as human shields, secure in the knowledge that when civilians die, most of the international community won't say how terrible of Hamas to use civilians as human shields. That's illegal under international law. It's illegal under American law. It's those damn Israelis. They're as damn Israelis. They need to be punished for this. And in this sense, international law is being used as a cudgel, a weapon against Israel, and not at all against Hamas or Hezbollah or any authoritarian government. So we have a kind of two-tier system, or maybe a three-tier system, which is what applies to most of the world, what applies to the authoritarian powers, and then what applies to Israel. Only Israel it applies to. You want to say a word about this, or before?
Yeah,
Natasha, take a breath.
I agree completely. I mean, the problem with lawfare and the problem with the ICJ decision and the ICC's actions.
And just International Criminal Court, International Court of Justice, make sure everybody knows. Yeah, we're going to get back to those in more detail.
That the problem is that they are being used as weapons by scofflaws against those who actually care. They're being used against the United States. They're being used against Israel.
Yeah, against the United States, for sure.
The U.S. and Israel try to abide by international law. They care about their reputation for abiding by international law. So the courts are being used as weapons against them by countries and parties such as Hamas who don't care at all. And it's obvious if you read the Hamas charter, if you read what I quote in my book about lawfare, what the Chinese government military manual says, well, we'll use international law. We'll hold the other side to it, but we'll apply it flexibly, right? If you look at what the Iranian leadership says about international law, they call the Universal Declaration of Human Rights, there's a quote, Khamenei called it mumbo jumbo by disciples of Satan. So they completely disregard it, but they use it as a weapon against those who actually care about their reputation for being law-abiding.
And if you look at, for example, the demonstrators, let's call them that, on the campuses, a lot of them are arguing, wait a minute, if under international law, as we decree it is, as we understand it, if you are resisting injustice, if you are resisting colonization, which we believe is going on, if you are resisting imperialism, none of which happen to be true, but if you are resisting, you can't tell us how to resist. We don't have to abide by humanitarian law, the laws of armed conflict. We get, as resistors, we get to rape, we get to murder, we get to kill babies, we get to take hostages, we get to hold hostages, we get to torture hostages. That's essentially what they're saying on their campuses. And sadly, you have their professors marching with them rather than saying, no, you don't understand the most basic things about international law. It's really quite extraordinary. Now,
there are a lot of aspects of this that you both have very rightly raised, and much of it comes down to jurisprudential, philosophical questions, which we won't have time to go into in sufficient detail for sure, as to the existence of international law. And does it depend on there being an enforcement mechanism for it to exist? I mean, when I was at university, I was reliably informed by my professors that most states adhered to most international law most of the time, and therefore it was sufficient for us to recognize its existence. But I think that the issue that you raise, which means that we have to grapple with these propositions and these legal frameworks, is that international law is being so badly abused to justify these absurd positions. And it's not just prevalent on university campuses and these encampments. We see it in the media. We see it in international political discussions. We've even seen it inform supposedly the decisions that have been taken most recently by the UK government and the arms embargo that it has instituted with respect to 30 licenses for export to Israel. We see it always being deployed in the context of discussions at the United Nations, and we see it in the legal academy. And when you say these professors are there endorsing some of the abject nonsense that is coming out from these students, we've seen the Academy on International Law leading many of these developments, these abuses of international law, to pursue a political agenda against Israel. And it makes me really have to grapple with this notion of the evolution of anti-Semitism, that it has focused now on these modern blood libels. We all knew about the ancient blood libels that Jews would kill Christian children to use their blood for religious ritual. They were extremely widely believed. It was pervasive. But the modern blood libels don't focus on Jews as a religion, don't even focus on Jews as a race anymore. The focus is on the Jewish state. And so these modern blood libels of occupation, ethnic cleansing, colonialism, apartheid, and now genocide, that is the framework through which these efforts to discredit, to delegitimize the Jewish state are happening. And I would suggest that's why we have to meet them head on, whether you believe in international law or not.
Well, yeah. I mean, it's not a matter of so much of believing in it. It's a matter of, I think, being very candid about its failures right now in that it is being used differentially. That it is not that, again, if you're China, you don't need to obey it. If you're Iran, you don't need to obey it. If you're Hamas, you don't need to. And you don't need to worry if you're Hamas that the Israelis will say, okay, I understand. Hamas doesn't obey the law of armed conflict. So in this case, neither will we.
Not to be the complete harbinger of bad news, but I actually think it's even worse than that.
Okay.
Iran rejoined the compulsory jurisdiction of the International Court of Justice over a year ago. Iran is not an adherent to international law as Orde, set out extremely powerfully. Why did Iran rejoin the compulsory jurisdiction of the highest court at the United Nations, the International Court of Justice, if not itself to seek to use these international legal institutions for their own agenda, to seek to abuse international law in this fashion? And that has consequences for the rule of law generally, for international legal order, far more broadly than just Israel.
And we were talking before we began recording, and Orde, you were saying about the Europeans see international law as a religion. Well, if that's the case, they should take their religion seriously. You would think, and say, no, because we believe this is really important. I mean, we're post-religious, post-Christian societies, therefore it's going to be about law. Then they should be eager to adhere to and to make sure that that Israel and China and Russia and Iran and Venezuela, that they're all subject to international law and that there is equality under the law. But that's not the case. And I'm talking about it in Western Europe. I spent about an hour with an ambassador from a Western European country yesterday. I won't say which one, but it was clear to me what he's most interested in is the Arab street. And I'm not talking about the Arab street in an Arab country. I'm talking about the Arab street in his country. That's what he's worried about. You see what I'm saying? So yeah, I don't know if you want to say a word in favor of Europe, but and a Western Europe, but I'm dubious about how they're approaching this.
Yeah, I think Natasha, and maybe you could elaborate. You made a very interesting point before this talk about how that may be a particularly valuable vector for pushing back is if they see international law as a religion, explaining to them how the overall project of international law is being undercut by its selective misapplication to Israel may be a way of effectively pushing back. And I wonder if you spoke very eloquently about that earlier.
Well, thank you. Well, I think one of the key messages to get across, and I think it's important because of the threat that Western liberal democracies face as a result of this politicization of international law, as a result of this particular agenda, is not just that the international legal order becomes devalued and international legal institutions lose their credibility. We've seen this with the International Court of Justice, that the fact that the president of the court has refused to recuse himself, despite his absurd track record of making allegations against Israel as Lebanon's ambassador to the United Nations. The idea that he would now sit in judgment on the very same issues which he has already made his views perfectly plain on.
And that the Europeans who support, and not mostly the Europeans, not just the Europeans, who support, who pick up the bills for his salary for the court, they should be saying, well, you know what, we want this to be taken seriously. You do need to recuse yourself. But no European nation's doing that.
That's right. They're not.
And so while one aspect of it is the issue of devaluing international law more generally, there is a real threat that this weaponization of international law is not going to stop with Israel. The US is in their sights. The UK is in their sights. And all other Western liberal democratic states that respect the rule of law are ultimately, I think, going to find themselves amongst the targets unless there is some wholesale pushback against this phenomenon of lawfare in the very near future.
I think people are also confused about the following, so I want to be very clear. The UN General Assembly, does it have the power to make international law?
Certainly not.
Certainly not.
The only body at the United Nations that has the power to pass any resolution with legal teeth is the United Nations Security Council. and only under Chapter 7 of the UN Charter. So the UN Charter...
Which it is not normally operating under, let's be clear.
Well,
right. Yeah.
And with good reason,
Yeah.
because it's hard enough to pass a resolution at the UN that doesn't have legal teeth. I mean, one example of a Chapter 7 resolution was to order Iraq out of Kuwait and mandate measures to be taken if that was not complied with. Another was just after September 11th and the mandate to all member states of the United Nations to take measures against terror financing. But these Chapter 7 resolutions are few and far between. Any resolution that the UN Security Council has passed with respect to Israel has in fact been under Chapter 6. And it, just like a General Assembly resolution, is a political, not a legal instrument.
It's advice, essentially, not law. Is that fair, or how would you characterize it?
So the reason I wouldn't necessarily use the advice aspect is because, advice suggests that it has some kind of legal basis. You'd get advice from a lawyer. It's a political resolution. I mean, the UN General Assembly could get together and decide tomorrow that the moon is made out of cheese. That doesn't mean that has any rational, legal or sensible basis to it. The reason that Chapter 7 resolutions are significant is because they will usually come with some sort of enforcement mechanism. And so that may be sanctions. In some circumstances, that may be mandated military action, which the United Nations Security Council can sanction in that format and through that mechanism. And I suppose that takes us back to the very start of this discussion and, to what extent international law can be enforced. Well, it's those enforcement mechanisms that give UN Chapter 7 resolutions the proper clout.
And those resolutions, of course, have to be agreed to by not just the U.S., but, say, Russia, which is a permanent member of the Security Council, and China, which is a permanent member of the Security Council. And they're not going to agree to any resolution that hurts them or hurts their allies, by the way.
And in that respect, I completely take the point that even the legal mechanism at the United Nations is inherently going to be politically influenced.
The UN Secretary General, Antonio Guterres, he obviously cannot make law on his own behalf.
Certainly not.
A lot of people think, well, he can interpret it. He can say, well, this is what the customary international law says. This is what international law says. My guess is he has no authority to do so and probably has no particular expertise to do so. I mean, he might, but I guess he's a lawyer by training, but that doesn't mean he knows this stuff.
Well, just going according to some of his public statements over the last 12 months, I'd suggest that we approach that with a significant degree of caution. But you're right. The International Court of Justice, which is the highest court at the UN, does have a capacity in which it can advise. It has done so recently with respect to Israel in the context of the advisory opinion that the General Assembly sought.
In this case, advisory.
Advisory, not legally binding.
Not legally binding.
The only legally binding determinations that the International Court of Justice can give are those where states have a bilateral dispute and they both have acknowledged the jurisdiction of the court to determine that case.
A little like treaties and contract law, with both sides say, would you help us? Fine, but they don't. But the International Court of Justice has another right to simply say, we're going to go in and decide this so as we choose, and there is nothing about the various judges or justices on that court that necessarily means that they're going to be fair or even attempt to be.
Well, the judges come from a variety of different jurisdictions. Not all of them have the same commitment to the rule of law that our respective countries share. So you're right that it's not just a complete mix of common law and civil law jurisdictions, but also varying degrees of commitment to law, unfortunately, are the legal traditions that these judges inevitably are drawn from as representatives at the World Court.
You should probably discuss briefly so people understand the difference between the International Court of Justice and the International Criminal Court. Or do you want to explain that simply to people?
Sure, absolutely. The International Court of Justice is a UN body of which all UN member states are parties to the International Court of Justice. And the International Court of Justice is there to decide disputes between states Two states have a dispute. They go to the International Court of Justice. It also has authority to advise UN bodies on the content of international law. However, that advisory function has been misused in the case against Israel. What it's been basically used to do is to opine on a dispute, the dispute between Israel and the Palestinians. And I know the U.S. and I think also the U.K. are very concerned that a precedent is being set there of circumventing this principle that under the International Court of Justice, you have to agree to the case being brought to handle a particular dispute. But here we have a situation where the UN General Assembly posed a question to the International Court of Justice. The question itself was written in a very discriminatory way, designed to get a certain answer out of the International Court of Justice, and that to me was very problematic. In contrast, the International Criminal Court is a body where the U.S. is not a party and Israel is not a party. There are only 123 member states, and the International Criminal Court is about particular individuals, prosecuting particular individuals who have violated or accused to have been violated major international crimes, war crimes, crimes against humanity, etc. And what the International Criminal Court is supposed to do is defer in various situations. It is supposed to only have jurisdiction over countries that have chosen to become a member of the International Criminal Court. And in all cases, the International Criminal Court there's a principle of complementarity, where the International Criminal Court is only to get involved when a particular country's justice system is not genuinely prosecuting the particular alleged war crime. So in those two ways, the International Criminal Court ought to be standing back from going after Israel or, frankly, the United States. But the International Criminal Court is violating its own principles and its own charter by going after Israel, despite the fact that Israel is not a member and has a robust judiciary that does its own investigation of alleged war crimes.
So if they're violating their own principles, they should be prosecuted for that by some judicial body.
Well, interestingly enough, Natasha's organization is in fact taking the International Criminal Court prosecutor. Natasha, you can talk about the measures you've brought before the Bar Association of England and Wales on precisely those issues.
Well, there's the problem with respect to the court and the lack of jurisdiction, which Orde's raised, and that is difficult because there isn't really a mechanism to challenge the determination of the court itself. Already in 2021,
no appeals court, no Supreme Court, no
There was a determination that was made on a provisional basis, finding jurisdiction to open an investigation, and the pretrial chamber in 2021 did say that the question of jurisdiction was still an open one, and that subject to any application for warrants in due course, it would have to be looked into once again. What we had most recently was an application that was advanced by Karim Khan, the current prosecutor, for warrants not just against several Hamas leaders, but also, if you can believe it, against Benjamin Netanyahu, the Prime Minister of Israel, and Yoav Gallant.
Moral equivalence, essentially. Oh, I don't like Hamas, I don't like Israel, who knows? We're somewhere in between. Yeah.
Yes. Well, if we're talking about moral equivalence, it's probably worth going all the way back to October, which was the first time that Khan visited the region. He went to the Rafah crossing, didn't go into Gaza, but even then, he had said that the alleged crimes of Hamas would have to be investigated and that Israel would need to prove that it was complying with the law of armed conflict in Gaza. So for a fellow member
that is complying. In other words, not presumed innocent, but presumed guilty is essentially what the principle he's acting under.
Complete inversion of the burden and standard of proof, which is something that certainly if you go to law school in the UK, you learn in your first week of criminal law, that you are innocent until proven guilty, and it's the prosecution that always carry that burden. Absolutely. So that was, I think, the first telltale sign that something was amiss. It's also, I believe, unprecedented to have such a public announcement of warrants. These are most often announced in secret because you don't want the subjects of these warrant applications to know that they're liable to be arrested if they're in a jurisdiction that will implement a warrant from the International Criminal Court. Not so here. We had a press conference. We had, I think, an interview on Christian Amanpour. We had a celebrity, star-studded, supposed panel of experts, although all that this panel seemed to have done is look at the material that they were provided by the prosecutor himself, material that he summarized in a public statement of his application. And so what UK Lawyers for Israel has done is looked at the summary that the prosecutor's office put out to understand what the basis upon this application for warrants was. We found that every phrase of every sentence was false. We articulated this in detail, albeit that the page limit was a severe one that was imposed on us as part of a submission to the International Criminal Court, to the pre-trial chamber that was determining this warrants application. We had permission to make this submission. It was made, and nothing was done as a result of it. Now, not only did this submission highlight all of the inaccuracies in the material that the prosecutor had publicly announced he was putting in front of the court, it also highlighted all of the subsequent information which had come out, which equally needed to be put before the court in accordance with prosecutorial obligations of continuing disclosure, of impartiality, of being an officer of the court. And so in light of a letter that we wrote highlighting these deficiencies and there not being any response, it's right, and it has been publicised, that UK Lawyers for Israel has made a complaint to the Bar Standards Board and also to the ICC Office of Court Oversight. And we shall see whether or not anything happens as a result. But the principle is a significant one. It is one I have always taken seriously as a member of the English Bar. You act with integrity, with impartiality, with honesty. You act as an officer of the court. And when I have prosecuted my own cases, you are always at great pains to ensure that you are never misleading the court, you are never withholding any information that may be critical. And that is a tenet of not just the English legal system, but I think so much of what has informed the international legal system and those that prize the rule of law more generally.
I expect, Orde, that you're disappointed in Karim Khan, because I happen to remember that you had rather high hopes for him when he took that job from the last and succeeded to, what was her name?
Fatou Bensouda.
Yeah, right. Is that a fair thing to say?
Yeah, so it's absolutely correct. Karim Khan stepped in sort of at the last minute as a candidate. The ICC powers that be had sort of teed up somebody named Fergal Gaynor to be the chief prosecutor. He was well along in getting selected. Fergal Gaynor was literally the lawyer against the U.S. and Israel in various cases. And Karim Khan was, it was expected that he would be better than Fergal Gaynor. And indeed, he came in and he basically froze the investigation of the U.S. vis-a-vis Afghanistan, and he took no action on the Israel file for quite a while. When it came to October 7th, he came under pressure, and maybe he sort of changed his mind. Political pressure, and maybe changed his mind. And he has now decided to move forward in an egregious way, abused his position, in my view, to go after Yoav Gallant and Benjamin Netanyahu. One thing that was particularly surprising about how Karim Khan did it was that he was scheduled to fly to Israel for sort of a visit. This was, if you are serious about complementarity, which is a key principle of the ICC, this idea that you first you see if the country whose nationals you're about to prosecute, if the country is robustly investigating. He was all set to fly to Israel, he and his team, and talk to the Israelis. The Israelis were going to welcome him, explain what they were doing, and he chose not to do that. He just suddenly, and surprised apparently even a lot of people on his team, decided, nope, we are going to request arrest warrants for Israelis. So that really calls into question what he's doing here. And it seems to me makes it clear that this is what he's doing is he's playing politics, not law.
Just one point of explanation, because I appreciate there are slight differences in the legal profession between the UK and the US, and perhaps a word in Fergal Gaynor's defense. We, as members of the English bar and the Irish bar in Gaynor's case, you are impartial, you are instructed by clients, and you argue that case irrespective of your own views. And in that respect, the idea that you would necessarily be beholden to views that you have argued in the past is out of keeping with the mechanism. We in fact, we call it the cab rank rule, because you take the first case that comes along that is suitable to your expertise and your level of experience. And so there isn't this idea that you pick and choose clients, or you have in some way an affinity or a particular allegiance to a client that you may have represented in the past outside of your role for that particular mechanism. But it's absolutely right that what we have seen, I think, since the investigation against Israel was started is a desire, and this isn't just attached, I think, to this current prosecutor, but to many of the mechanisms at the ICC, a desire to rehabilitate this court. This has been a failed international court in terms of the money that has been spent on it, the successful prosecutions that have come out of it.
Very few.
The court's focus on African defendants.
Mostly,
almost exclusively. It has come under tremendous criticism. And several years ago, there was an in-depth analysis, a report highlighting many of these issues. What better way to rehabilitate yourself as an international court than to go after the world's punching bag, the Jewish state? And I think inevitably that has to have factored into this in some way. There's no other explanation.
Absolutely right. And I do want to be very fair. I want to give essentially a shout out to someone. And that would be the Vice President of the International Court of Justice, Julia Sebutinde of Uganda. She should be a well-known name because she is somebody who has made it very clear that she intends to be objective, that she is not going to determine her judgments based on Hamas talking points, that she is going to look at the merits. Twice she has refused to join the Israel haters and accused the Jewish state of genocide. But now, and this is another subject I want you to touch on, we learned that South Africa's ANC, which has brought the charge of genocide, cannot provide any evidence of that. They would really like the conviction first, and maybe the evidence can follow that. That's really what they're saying. Of course, it's very convenient for those in the media, not just social media, but major media, who want to brand Israel as genocidal or apartheid, to say, look, South Africa has made this accusation, and therefore it must be the case.
No smoke without fire. No smoke without fire.
No smoke without fire. It must be. But by the way, but South Africa has not been able to provide any evidence. And by the way, let's just to be clear, the idea that Israel is an apartheid state, 20% of Israelis are not Jewish, mostly Muslim and Arab. They not only have more rights and freedoms than minorities anywhere else in the Middle East, they have more rights and freedoms than majorities anywhere else in the Middle East. And the idea that Israel is fighting a genocidal war in this war against Hamas is also ludicrous, but this is what the Soviets and really the Nazis knew to do. Whatever you want to do, you accuse your enemy of. And then people can say, well, who knows what the truth is? I mean, they'll both say, but Hamas, Hezbollah, the Islamic Republic of Iran, since 1979, has been very open and clear that they are threatening and inciting genocide, which I believe is a violation in itself of international law.
Under the Genocide Convention.
Under the Genocide
Yes.
Convention. But again, there's been no price paid for that. So now, again, for those watching and those listening to Julia Sebutinde, that's very helpful, but it's not what is going to dominate through most of the media. It's going to be the accusation that Israel is a genocidal state, is a colonial state. And of course, I've said this before, but it's important for people to realize the establishment of the state of Israel, the establishment of a homeland for the Jews in a territory that was theirs. This was decolonial and anti-imperialist. This was the first time that those territories in over 1,000 years had not been under foreign imperial rule. The first and only time. And you've talked about this separately. I think it's a very important point that if we're talking about, say, the West Bank was taken by the Jordanian army, with some English officers I might mention, and occupied.
Absolutely.
And occupied, and the Jews were ethnically cleansed from that territory, and religious sites were desecrated in that territory. And in a war that was waged against Israel, a defensive war, Israel took that territory back away from Jordan, which never properly, and then said, maybe we can trade this for peace with the Palestinians. But in no way was it Palestinian territory. And you've explained this at some length, and it's a difficult explanation why this is not Palestinian territory, just because, I don't know, the UN Secretary General or someone or some rapporteur at the UN says, oh, yeah, it's a Palestinian territory. We've all come to use that language, and I would argue the Israelis have not been good about saying we do not accept this language. They end up, oh, yeah, it's the West Bank. Oh, yeah, it's the occupied West Bank. Oh, yeah, it's the occupied Palestinian. And they kind of give away a lot rhetorically without understanding the consequences of doing that. That'd be a criticism of Israel and how they do their public relations, but that's for another time. Anyway, I throw that open to you if you want to, yeah.
Well, I think it's a critically important point because the misstatements about the status of the territory and the status of the territory under international law inform absolutely every other aspect of the misinformation about international law and allegations that Israel's breaking international law. And it does come down to the question as to what was the status of the territory at Israel's declaration of independence on the 14th of May, 1948. And there is very clear international law that helps us with this. There's a rule of customary international law called uti possidetis juris. And the short version of the explanation is that Israel essentially takes on the pre-existing administrative lines of the British Mandate as its international borders automatically. That's as an operation of this rule of customary international law. And as you've described, immediately upon Israel's declaration of independence in this war of annihilation that was waged against that fledgling Jewish state, Jordan does occupy the West Bank and East Jerusalem from Israel. It's ethnically cleansed the Jews. My great-great-great-grandfather's gravestone, I think, was used to pave a nearby road. Torah scrolls were desecrated, synagogues destroyed. And so when Israel recovers that territory in 1967, the status of that territory hasn't changed. Jordan's occupation of the West Bank and East Jerusalem doesn't change the underlying status of the territory at all. So Israel recovers what is essentially Israeli sovereign territory, but it doesn't apply its law administration and jurisdiction in full to the West Bank, as it did with Jerusalem when it reunited that city. It applied a temporary framework that I think has prompted everyone to use this false legal analysis, this legal terminology of occupation. But it did so in order to seek some sort of future peaceful solution with Jordan, because the Palestinians as a separate entity there really had only begun with Yasser Arafat's establishment of the PLO in 1964, so very shortly before this war. The concept of exclusively Palestinian or exclusively Arab Palestinian national identity arose only then also. My grandparents were Palestinians. They were living in the British Mandate, and they had identity cards issued by the British that said, race, Jewish, nationality, Palestinian. So we're looking at, certainly the rewriting of international law here and the inversion of it, but also the historical narrative, which has been completely inverted and rewritten to suggest that there was a Palestine which was taken away from a people. The British mandate Palestine, and we've seen the money that was used that says Eretz Israel on it, the land of Israel. We've seen the flag, the football team, who comprised it, the Jewish players. We've seen the Visit Palestine posters that were produced by the Jewish agency.
Palestine Symphony Orchestra, which was Jewish, the Palestine Post, which was a Jewish newspaper. We can go on and on and on.
Indeed.
But yes, when you talked about Palestinians back in 1930s, you're talking about Jews. Yeah.
And yet we've seen all of this being completely inverted. I echo everything you have said about Julia Sebutinde, her integrity, her bravery, and her clarity and legal analysis that she has put forward in every single dissenting opinion is extremely valuable. And she has also set out the historical narrative, the realities in juxtaposition to the fantasy, I'm afraid. There's no other word for it, that has been put forward both by the majority opinion in the context of the advisory opinion, but also in how South Africa's case has been treated on the question of genocide. This utterly morally repugnant allegation that is made that inverts, that blames the victims of genocide, of the crimes that were perpetrated against them. And I don't just mean the Jewish victims of the Holocaust, because this is where the term genocide originally came from.
Yes.
It was coined by Raphael Lemkin in the aftermath of the Holocaust to provide legal terminology to the Jewish experience of being targeted for extermination because they were Jews. I also mean, Cliff, the victims of genocide and acts of genocide perpetrated on the 7th of October, because Hamas has made no secret of their genocidal intent and the genocidal acts. They were captured on GoPros. They were spread around the world on social media in real time. This stands in juxtaposition to the case that South Africa has advanced thus far, where it has misrepresented statements from Israeli officials alleging a genocidal intent, and further falsified the factual position, the position that was being put forward in terms of what was happening on the ground, in terms of targeting, in the context of the armed conflict in Gaza, in terms of the admission of aid, all of which has been refuted by Israel's team at the ICJ. But the important thing to acknowledge is that thus far, the court hasn't considered any of this material. The provisional measures orders that the International Court of Justice has given thus far have explicitly indicated that they're not assessing the merits, the actual evidence that has been advanced so far at all. And there is no assessment that has been made as to the claims that South Africa advances, but for, and this is very, very narrow and has been widely misrepresented, the only thing the court has assessed is whether the case that South Africa has brought falls under the Genocide Convention. Mm-hmm. Is South Africa bringing an issue that is subject to the legal determination of the court? That was what they meant by plausibility.
Right. Didn't mean genocide was a plausible case, but of course, so much of the media has misinterpreted, distorted that decision, and for their own purposes, so that they're saying, no, that's what the court said, that there's a plausible case of genocide.
And it took the former president of the International Court of Justice, Joan Donoghue, many, many months before she came out on Hard Talk on the BBC to say, actually, let me clarify. Everything that people have said since January has in fact not been what the order said at all. I wish that more lawyers had sat down, or legal commentators, or even journalists, it wasn't a particularly long order, had sat down and read the document, because I would suggest that it is perfectly plain and written in English as to what the court had determined.
But it's longer than 140 characters, probably.
Fair enough. I'm sorry. I'm not on Twitter or X, is it? Okay, so my attention span is still a little bit longer.
Many other subjects we could hit before the end, but one I want to get to, and then I'll let you just tell me what else you'd like to get to. Since you're here, since you're from England, we talk about the media being bad. I'm not sure there's any media platform that's worse, I'm sorry to say, than the BBC. And I am sorry to say that because, when I was younger, when I lived abroad, when I lived in Africa for a number of years, I had a shortwave radio about the size of a bread box. And every night I'd turn on the BBC to find out what's going on in the world. And I trusted the BBC. And the BBC has been so bad. And while I'm mentioning this, I should also say, the Labour government, and particularly Foreign Minister David Lammy. Wow. Does he understand any of these things? It's been very disappointing to me because, again, I think the U.S., we have a special relationship with Britain. I look to the Brits for many things. I talk to someone like you who has a posh English accent. I immediately think your IQ must be way higher than mine. So it's disappointing to see this coming from England.
Well, on David Lammy, I was at the Warner Theatre last night with Douglas Murray, where he's very kindly invited me on his US tour.
Wonderful man.
To Save the West. And he referenced David Lammy's outing on Mastermind, which is a British quiz show, which is relatively high level in the questions that they ask. But his response, as Douglas elucidated last night, to the question as to which English king succeeded Henry VII was to say it was Henry VI. Which you don't need to know very much about English
basic math
history to understand perhaps isn't quite right. But that is an indication, unfortunately, of some aspects of our current Foreign Secretary's abilities. The recent determination of this arms embargo against Israel that has suspended 30 licenses is under challenge by UK Lawyers for Israel. We have written at some length as to why we view this decision as unlawful, and that may yet lead to legal proceedings. But it has come, unfortunately, this is the latest decision after several, including refunding UNRWA, despite its complicity with the 7th of October, subject to detailed analysis by UN Watch and other international NGOs that have indicated individuals who were involved in the 7th of October attacks who are associated with UNRWA. But also when you step back and you consider what the major factors that led to the 7th of October are, I mean, ultimately, the indoctrination that generations now of Palestinians have been subject to from kindergarten up is first and foremost. 3/4 of those that crossed the border from Gaza into Israel on the 7th of October and committed these barbarous medieval atrocities were educated in UNRWA-run schools, according to UN statistics. Educated to believe that the highest calling in life is to become a martyr and kill as many Jews as possible. So the UK has refunded UNRWA under the current government since they've come into power. And of course, the other aspect of this was to decide not to make any submissions to the International Criminal Court as to the jurisdictional questions which the previous government considered it to be in the UK's national interest to do. So one has to step back and consider to what extent, politics is driving, unfortunately, an awful lot of the decision making here. But the real concern is that if the UK is abandoning its major ally in the Middle East, the only democracy in the Middle East, this isn't just bad for Israel. What message does that send to other allies of the UK? And especially when we consider, we've had recent reports, I believe it was the Times yesterday, that indicated that the US was trying desperately to prevent this decision from being taken, a decision that we say is not based on any legal analysis, but essentially based on political considerations. It's important for your audience to understand that in the last election, the Labour Party, which has its own very troubled history with anti-Semitism and hatred of Israel, was outflanked by several independent candidates that won against the Labour Party candidate in respective constituencies, standing on a Gaza-only platform. The party leadership is under an awful lot of pressure to do what it can against Israel to shore up its domestic political support.
This Gaza-only platform, meaning pro-Hamas platform. And this is British Muslims, British leftists, or a coalition of the two?
It's often a combination of the two.
Or you're in the weeds on this all the time. There's a million subjects we could have raised. What else would you like to raise before we close out for today?
Well, I'd say that one question I'd have for Natasha is, what is your sense of why the British and other European media take such a hostile approach to Israel? Is there anything that can be done to change it? And do media outlets like the BBC shape British consciousness towards Israel? Or do they simply reflect the prevailing public opinion?
It's a chicken and eggs question, isn't it? I mean, both of your comments on the BBC are completely spot on, and there has just been now released a very substantial report, which I'm glad to say that UKLFI was able to contribute to in some respect, led by Trevor Asserson, who is a British lawyer, and assisted substantially by artificial intelligence in analysing huge volumes of reports on Israel, and the not just the bias, but the complete inversion of reality is plain when you look at this report. But of course, it's been plain for anyone with an understanding of what's happening on the ground, watching BBC coverage over the last year. I've been very rarely on the BBC and tried to engage in delivering some degree of balance and a perspective that addresses both the international law.
They don't particularly want you on the BBC, you would say?
That's not been my impression.
And they interrupt you when you're on, right?
The general approach, it has seemed to me, is that rather than being invited on as an expert in international law, which is the way that they certainly have pitched these interviews to me, that there is a desire to sort of deal with me or seek to, or in fact, one presenter, Christian Fraser, after perhaps failing to deal with me, did close the interview by saying, "Always great to debate with you, Natasha," which I'm sure he meant in a charming, sort of friendly fashion, and that we'd come to the end of this exchange. But I'm not sure what other commentators they invite on to debate with in that particular fashion.
You could say I have so little opportunity to debate. Hamas spokesman, I'm very pleased to be here too.
Well, I appreciate your attempt at being facetious, but there is, of course,
I attempted a lot, not successfully most of the time.
There is a kernel of truth in this, which is that the BBC, of course, have been reporting Hamas casualty figures, despite the fact that they've been debunked consistently.
Gaza Health Ministry said.
Absolutely. And serving as a Hamas propaganda mouthpiece.
Yes.
Not being honest about the fact that the reports that they have coming out of the ground, from the ground in Gaza, are under the control of Hamas, the internationally prescribed terrorist organization. I'll give you one example there, if I may, as we're closing, and it's become relatively famous now, the reporting on the Al-Ahli hospital strike.
I thought you would, yeah.
Jeremy Bowen, when asked after it had been perfectly clear that the BBC got this disastrously wrong.
In other words, we just hope people remember, it was the bombing of the hospital was blamed on Israel. It was actually not Israel. It was actually Islamic Jihad or Hamas rockets. Yeah. It didn't hit the hospital. It hit the parking lot. They exaggerated the number of everything about it was reported wrong because people like Jeremy Bowen, who has a long career in this, by the way, simply took Hamas's talking points and reported them from the BBC.
And did Jeremy Bowen regret it?
No.
Absolutely not.
That's what you're going to get to, yes.
So I was supposed to be on in that hour. I was on the line waiting to begin my interview when the rolling coverage of the Al-Ahli hospital strike began, and that they started immediately calling it an Israeli airstrike. And I received a phone call from the deputy editor of the channel, and I'd been bumped already a number of times before in the run-up to it. "Natasha, I'm so sorry. I know the full history. We're going to have to bump you again in order to run with the rolling coverage of this." I said, "What are you talking about? Now more than ever, you need me on. I'm watching your commentators calling this an Israeli airstrike." This was nearly an hour after the first reports had come out. I said, "I'm already looking at reports online that it was a Palestinian Islamic Jihad rocket that fell short. I hadn't seen that on any of the wires," was the response that came through.
Mm-hmm.
And in any event, there was no can do. We're going to have this interview on another occasion. And all I did was implored this journalist to exercise basic journalistic skills. And what didn't even suggest that they send someone down to look at the hospital down the street, right? Gaza is a very small place where they would have seen that the hospital was in fact intact. And as you say, that this was actually an explosion that occurred in the car park. I wasn't even suggesting that at the time. I said, look, there are things that we know and there are things that we don't know. We know that Hamas and Palestinian Islamic Jihad keep weapons caches next to schools and hospitals, and they're using schools, hospitals, mosques, clinics as command and control centers and rocket launch sites. Factor that into your analysis, where you don't know where this strike has necessarily come from. We know that their rockets frequently fall short in the Gaza Strip. In the previous exchange, about a third of Palestinian Islamic Jihad rockets fell short in the Gaza Strip. And unlike Israeli strikes that are targeted and proportionate and subject to an analysis and intelligence assessments, these rockets fall indiscriminately. And of course they kill both Palestinians, aid workers, you name it. So we know that those rockets fall short, and we know that Israel doesn't target hospitals. And I got the phone put down on me. So, it just, even seeking to appeal to what I grew up with as a notion of, journalistic, rigorous analysis, questioning, integrity, didn't quite seem to swing it. And the only explanation, or the best explanation, I should say, that I received, this was many, many years ago, where Matty Friedman wrote a series of articles about his experience working with the Associated Press in Jerusalem. And it's a combination, and absolutely, but he talked about the editorial lines that were coming out of the Bureau. Yes. And it's a combination, I think, of, what sells, what they think sells, whether or not it has any reflection of the realities, but also of the kind of received wisdom and what is expected to be written.
Well, and also this, if you're working in Gaza, you better not go against Hamas. Your life is threatened if you do. If you're working with a fixer, his life is threatened. You don't want to do that to him. What all this means is that the reporting coming from Gaza over years has been distorted. And of course, journalists and their editors don't want to admit that. And Matty Friedman, what he did was, I'm blowing the whistle on all this. No, almost nobody else has done so. And a lot of people have denied it. But there was no objective, fair report. If a journalist there saw a Hamas terrorist launching a rocket, he didn't take a picture of it, and next to a hospital, say, and he didn't report on it. He ignored it. He knew that he had to, and he did. He was complicit. They were all complicit.
Anywhere else, they qualify their reporting with this very critical piece of information, which is that they are subject to local controls.
Right. And they would say that in Israel, we're subject to local control. In Gaza, they wouldn't say that.
Well, except that in Israel, you have this tradition of free press, that the controls are the military censor. So sensitive information that might, injure or endanger troop movements is withheld. But that there is no other censorship in Israel. Yeah.
Well, Orde, thanks for being here with us today. We could go on, and I would like to, and I hope we'll do it again. Thank you, Natasha, so much for being with us. It's been my real pleasure, too. Thanks to all of you who have been with us for this conversation here today on Foreign Policy.